you on our first day of our PT Board of California board meeting with agenda item number 10.
So I believe we have a representative from the Department of Consumer Affairs that it will be providing an update and joining us live via WebEx. David, if you could promote them to panelists and open the mic for them.
To look here.
Hi, so you skipped ahead to me, so give me just a second. I'm Julianne Allen. I'm a legislative analyst with the Department of Consumer Affairs, and I will be providing the Department of Consumer Affairs update today. Our first subject is the hybrid telework transition. On March 3rd, 2025, Governor Newsom issued an executive order requiring all state agencies and departments to update their hybrid telework policies for employees and increase from 2 to 4 days in office per week, beginning on July 1st, 2025. At the end of June, agreements with several labor unions representing employees within the Department of Consumer Affairs were released, delaying the 4-day in office requirement by 1 year for most employees. We appreciate staff's flexibility as the situation evolved. Also have an update on travel. As a reminder, on June 9th, 2025, the Department of Finance issued guidance for out-of-state travel in the upcoming fiscal year. Travel outside of California will be limited to essential travel that is required to conduct state business, meaning requests should be made for only mission-critical needs. DCA distributed a memo to all boards and bureaus on June 16, 2025, detailing the criteria for mission-critical travel, including, but not limited to, enforcement actions, revenue collection, statutory requirements, auditing, and litigation. All requests must be provided to DCA's travel budget 8 weeks in advance to allow for review by DCA, agency, and the governor's office. If there are any questions, please contact your assigned budget analyst at DCA. We would also like to remind board members and staff of our collective responsibility to always work to minimize the cost to the state through responsible travel planning and scheduling. To best serve the public, it is incumbent upon all of us to ensure that we are being fiscally prudent in our decisions, especially when traveling for board business. DCA is reminding members and staff to evaluate if a rental car is always necessary versus ride-sharing services. Carpooling is also highly encouraged when renting vehicles. We know that there may be new travel costs board members are experiencing as well, such as baggage charges. So please keep receipts to ensure that you can be reimbursed. If you have any questions, please reach out to member relations at dca.ca.gov so we may assist you. Annual report update. Finally, the annual report is one of DCA's biggest projects. Staff work on this report throughout the year, gathering information and statistical data in order to compile a comprehensive report about the department's actions to submit to the legislature. On behalf of the director, thank you to board staff for your efforts and contributions. The annual report is published to the DCA website in the summer and has a wealth of information and memorializes all the great work done by so many throughout the department. DCA encourages board members to take time to review it and use it as a resource. In closing, please let DCA know if you have any questions or need assistance.
Thank you very much. I had a question about how we're doing with the return to office. I know we discussed it last time, Jason, regarding our staffing and is everybody now going back to the way that they were before with their flexible schedules, or did we make some adjustments?
We did make some adjustments. When the transition was ordered, we were already in the office mandatory 2 days a week. So we did all this planning to bring everybody in 4 days a week, just to find out the day before implementation of that plan that we were going back to the old plan. So while staff were all very relieved and it provided them, some solace when it came to things like childcare and commuting and that kind of thing, it didn't create much of a disruption for us in the office. It was very much status quo. And again, it's just been delayed for a year. So we'll be revisiting that conversation in about 6 months.
Have we made any adjustments to our travel decisions in light of the DCA requirements?
We have, as an example for this trip, and we spoke about it a little bit earlier, this meeting was for us a 5-day meeting. It started on Saturday and Sunday with the California Physical Therapy Association's annual convention where we had a booth. We then had an expert consultant training yesterday. We have the board meeting today and the finish of board business tomorrow. Typically, all what we call the travel team would attend the whole board meeting. In this instance, because it spanned 5 days, we kind of had to divide and conquer and split up. And so some of the members of staff were at the CPTA convention. A few of us were here yesterday for the expert consultant training, and then those of us are here today. And then we have some guests from other state agencies like the Attorney General's office that are here today, but they won't be with us tomorrow.
Great, thank you.
All in an effort to cut costs, transportation, lodging, and so on.
Thank you. Are there any other questions on the board for the DCA representative? Okay, we're going to continue then. Thank you very, very much for joining us.
Thank you for your time.
Take care, Julianne. I would like to go next to item number 10C, California PT Association representative. Come on down, Dr. Sims.
Good afternoon. Hello? Nope. Test. Okay,
There we go.
Good. Well, good afternoon, and I'm wearing a different hat now. Many hats sometimes, and I am now the liaison or the representative for the CPTA. Like your staff, it's been a long couple weeks of them leading up to the annual conference, and 12 and literally 14, 16-hour days for them. So they asked for me to come here. I live here, and so it's easy for me to talk here. The marching orders are the talking points they want me to share with you from the CPTA. They have the two sponsored events legislatively. The prior authorization bill, AB 574, is on the governor's desk waiting for his signature. And we appreciate, CPTA appreciates this board writing a letter of support for the, to the legislators. If I could have one more ask, is that if a letter can go to the governor's office to ask him to sign the bill. Don't know how. That was enrolled at the governor's desk on the 9th of September. So the 30 days for him either to sign it, veto it, or it becomes law without signature is coming up quickly. So I don't know how expeditiously you can go ahead and draft that letter, so if you so care to do so in support, consistent with your previous position already. The other one is AB 1458. That's the, oh no, not 1458, sorry. Gonna get there soon enough, you know that. AB 1009, and that's the teacher credentialing bill that also has passed the legislature and is here just says that it's engrossing and enrolling. I don't see a date of enrollment on the governor's desk. I don't know if that 30-day time clock has counted. He has 3 days to sign it, veto it, or it becomes law without his signature. And again, you guys, the PT board has wrote a letter of support for that, and it's greatly appreciated. And if that letter can be kind of now echoed again, but this time to the governor's desk. Title 22 is an issue that the CPTA has been working with, and that is a statutory event where it dictates the behavior of healthcare at the hospital and inpatient settings. And since statute trumps regs, we need the regs now to fall in line with the former AB 1000 for that the physical therapist in those settings can have access, or patients have access to physical therapists that way. It has not been very well or been very entertained by the things Department of Health is what department that falls under. Bob Wachowski, the senator who authored that bill for us, has written letters and stuff. So if there's any motivation for this board to contact that department also and say, hey, you really, it's over 10 years now that statute has passed, but yet the regulatory, corrections because of it have not yet occurred. we had a very successful annual conference. Kind of pivoted a little bit. When I was president over 10 years ago, we'd have 1,000 to 1,200 people at the conference. We had 688. Our goal was 500 for two reasons. One is the pandemic, and people just got so used to doing stuff online, and that's the reason why there's so easier just to get their Con Ed. I think Con Ed has been a kind of a driver of attendance at that conference in the past. And we were there at Palm Springs. The weather cooperated. There was some rain earlier in the week and weeks prior to that, but we were successful with that. And so, and then just a sidebar that the PT Association is in support of, they're not a sponsor of the animal physical therapy bill, but that's going to be discussed later. I don't want to be called out of order again. Got my hand slapped once. No, not really. But we'll have the discussion regarding that. And so I think that for me, and I was taught by a previous executive director that, as president of CPTA and me as executive director, if we agree on everything, Dr. Sims, one of us isn't doing our jobs. And so, but I don't think that prohibits us from also being collaborative too, in working in concert. I think what benefits the consumer of California, we're all, CPTA is for that, in addition to the practitioners and all the new practitioners behind me, soon to be, that we can also find ways to work together and make sure that we advance. Kind of consistent with the mission statement. I forget who said today. Was it you, Sam, that said the mission statement to open the meeting? I don't know whoever it was, but to advance, the profession of physical therapy, and Dr. Title Bill, consumer access. I want to make sure that the PT board also sees value in advancing profession with things that potentially they can initiate and also either be co-sponsors with CPTA, and we'll go from there. So with that, I'll take any questions regarding the CPTA's role in physical therapy.
Are there any questions from the board? In relationship to the two support letters that we wrote, AB 574 and I think AB 1009 that are on the governor's office desk. What's the process, and does that letter continue on to the governor's desk after we've already written the first letter last year?
While the governor's office does have access to the letters that were provided to the committees through the legislative process, there's always room for us to send a letter to the governor's office in support of any particular legislation that the board deemed appropriate. We would probably want to craft the language a little bit more to the audience that was receiving it, a little bit less legislation, and a little bit more governor's side of things, especially in light of it. It's made it through all the committees and it's ready to be enrolled. But that's entirely the pleasure of the board.
I'd like to ask the board members if they feel comfortable bringing it to the governor's attention in a more precedent manner for AB 574 prior authorization for physical therapy based on access issues and wanting to make sure that it stays ahead. Is there an interest in that or a discussion about that? Did you have a question?
Yeah.
Okay. All right. Well, I will make a motion that we write a specifically crafted letter to the governor regarding AB 574.
Madam President, I think we should probably take this up in the legislative report when we take up those items.
Okay.
Taking action during a report of a professional organizations, we should probably do it
We can do
in
that
area.
on agenda item number 11. Okay, no problem. All right, so you have time to think about it, is what I'm saying. All right.
10:09 also.
Any other questions from the board? Okay, all right.
10:09 also.
We will bring that up during
Yeah,
the legislative.
absolutely.
Thank you for the information.
Mhm.
Thank you, Dr. Sims. We're going to move on to the other component of our Consumer Professional Associations reports, and that is the Federation of State Boards of Physical Therapy.
So for the information of the audience that's in front of us today, the Federations of State Boards of Physical Therapy is a private organization, an association of 53 different jurisdictions of physical therapy boards of California. They're also the creator and administrator of your National Physical Therapy Examination, but they provide a lot of guidelines and a lot of guidance to the boards across the United States when it comes to a Model Practice Act that they work with in collaboration with the American Physical Therapy Association. This state participates heavily with FSPPT. One of the committees that we are participating on currently is the Sexual Misconduct and Boundaries Committee. We've created a few resources, and a few of those resources are tailored specifically for students. So we have a couple of videos that we'd like to queue up. Each video is about 4 minutes long. We have 3 of them, but I think it'll be good to see these before we head into even the student Q&A. And so if the facilitator would promote that to panelists and queue up the video, I'd appreciate it.
Physical therapy is an inherently hands-on profession. You're spending an entire hour, once, twice, 3 times a week, sometimes more, touching a patient, doing manual therapy, cueing exercises. And this profession also has the requirement that somebody may have to take clothes off. So it's inherently a profession that can make people uncomfortable. And that's why it's important that you're explaining what should be happening so that you avoid potentially the individual not understanding why you're doing what you're doing.
We've had cases in our regulatory board where the provider actually did not do anything bad, even though a complaint was filed against them. It was a matter of the communication.
When a student starts a PT program, they go in with this passion to help patients. And when you come out of school, sometimes what happens is you're so used to not having to explain what you're doing to your fellow students because they understand it, that you don't explain it to the patients when you come in.
One of your best tools in your toolbox is educating your patient in their own healthcare. The more educated they are, the better that you could communicate with them. The more educated they are, the less likely there's going to be any kind of confusion about modalities that are being provided to them.
It really is the responsibility of the physical therapist on that first visit to really lay the tone down for what is the physical therapy going to do for them? How is it going to make an impact on their life? The patient should really leave that first visit knowing exactly what is going to happen and what are the expected outcomes from that therapy intervention.
Informed consent is what I would want to drill into students as they enter into the profession.
You are gaining the consent of the patient after you've given them the information about kind of what's going to happen next. Here's why I'm doing what I'm doing. Here's what to expect. Is that okay? The first thing is you understand you're here for physical therapy, right? Here's what physical therapy is and what that means.
Students in the last years of their program, when they're doing clinicals, yes, you're comfortable with your fellow students, but you need to drill. You need to exercise informed consent. And in those drills, have those other students complicate that scenario a little bit. Be a patient that might have amorous feelings, run scenarios so that you become familiar with them and you know what to do if that situation provides itself in real life.
Maybe I'm working with a patient who has some lower back pain and they've got sciatica into the, the back of their leg. I might need to do some palpation in the buttocks area.
I don't understand as a layperson, as a member of the public, the connection between the nerves in my spine and the issues that are happening in my leg. They may think this person's touching me inappropriately, when in reality, you're doing a legitimate treatment. And it's just that lack of communication and that informed consent that you should have got from the patient that would have solved this problem and never brought a complaint to board or to investigation.
As a patient, I always appreciate a provider who opens by saying, this is a safe environment. You're always welcome to stop me in my tracks so we can back up and get to where we're on the same page.
What might seem very routine from one patient to another, day in, day out, throughout their whole career, is a single event in time for that patient.
Preventing issues, it puts you in a better spot. I'm going to put in place making sure that I gain informed consent, that I explain what I'm doing to my patients, that I ask for a third party to be available if I feel uncomfortable or if my patient is seeming uncomfortable.
If the provider had just communicated what they were going to do, why they were going to do it, all those things, then there wouldn't be a complaint filed against them.
By starting those habits early and doing them ahead of time, you're not having to justify the choices that you made, not having thought about them.
I don't think providers realize how much influence they have with their patients. I think some of us think, oh, we're just physical therapists, but that actually comes with a lot of weight.
Licensees, students, you never think something is going to happen to you.
In physical therapy, we develop a very direct relationship with our patients. Some healthcare professionals, it's at an arm's length. With us, it's one-on-one most of the time. And in that, there's an inherent relationship that develops.
The goal is to educate students that there's more to physical therapy with this whole patient-provider relationship.
I think physical therapists need to appreciate that how we're trusted comes with a really high-level responsibility. Sexual misconduct in the workplace is anyone who's doing something other than what they're supposed to be doing, touching a person in the wrong way, speaking to a person in the wrong way, introducing sexual language, sexual innuendos, sexual jokes. It could be your patient, it could be your patient's family member. There's no room for that.
Even though we're a very touchy manual therapy profession, sometimes they never think that something that they're doing could be misconstrued in a negative way.
You are responsible. It doesn't get shifted onto the patient. You're responsible for putting the brakes on when it comes to anything that could be construed as sexual misconduct in the workplace.
I think it's always important to recognize that there is a boundary between the provider and the patient, that your role as a physical therapist or a physical therapist assistant is to help the patient achieve their goals related to the problem that they're coming in for. It's not being integrated into their entire lives. It's not creating a lifelong relationship. It's helping them out in like a snapshot of time.
Students need to think about it right off the bat and recognizing that the bar is now even higher when it comes to a patient.
Because of the training of physical therapists, it's very task-oriented. Without proper communication, proper asking and getting consent where you're putting your hands on patients, it can get pretty sticky if any of those steps along the way are missed.
By the time they're ready to go out into practice, they may not be perceptive enough until they're confronted with the issue. Then there it is right in front of their face. They realize, oh, this is one of those experiences that they told me I might have. We try as much as possible to get them to think critically, what is the best thing for me to do at this moment, and what is in the best interest of the patients to protect them.
I think it's always in the forefront of the physical therapist to remember what they're doing, why they're doing it, how they're doing it, if it's okay if they do it with these particular techniques so that there's no misunderstanding.
You have to kind of be really aware all the time. I think it could happen to any of us.
I think we always all have that ability to be someone who violates those professional boundaries based on what's going on in our lives.
Preventing issues, it puts you in a better spot. I'm going to put in place making sure that I gain informed consent, that I explain what I'm doing to my patients, that I ask for a third party to be available if I feel uncomfortable or if my patient is seeming uncomfortable.
Communication is probably one of the biggest things that we see in many of our cases. And if the provider had just communicated what they were going to do, why they were going to do it, all those things, then there wouldn't be a complaint filed against them.
By starting those habits early and doing them ahead of time, you're not having to justify the choices that you made, not having thought about them.
With students, I think a little bit of it is exposure. And knowing that it's not just about a technique that they passed a written exam, that there's more to physical therapy with this whole patient-provider relationship. It is a professional-patient relationship, not a social friend relationship.
We all have our different boundaries in our personal life, but in our professional life, there is only one boundary. Your patient is your patient. You are a PT, and that there's a line that's very clearly drawn, and state laws address that.
With regards to students, we teach them to embrace the responsibility of being a physical therapist, but also keeping in the back of their minds, like how you deliver that care makes as much of a difference as the actual care that they're giving as well. Always remember the role that you play in your patient's health care, and always remember that those are the things that will keep you practicing for a long time into the future.
Just one more.
Every decision that a physical therapist or a PTA makes, they need to understand that there's a power and balance there, because that person's vulnerable. They're looking up to that professional for help.
We try to explain to students in educational curriculum to always think about that power differential of the patient-provider relationship and not putting them at risk for blurring that boundary or crossing that boundary.
The delivery of healthcare today isn't done with a doctor the way it was 30, 40 years ago. In fact, today you might see a doctor for 10 minutes total. What you will see is maybe a nurse practitioner or a registered nurse or a physical therapist for that matter, for hours on end.
People go to physical therapy because often they're in pain or they're not able to do the things in life that they want to do. They're already vulnerable. And if they're going to go to see a physical therapist, the physical therapist should know this about their patient and know that they have to be very conscientious about those boundaries.
When we go into that situation, there is inherently a power imbalance or a dynamic that you should be aware of, both the PT and the patient. You are not walking into this scenario with a patient on the same playing field.
Think about what you know about your patient when they come in to get therapy. You've looked through their chart. You know how old they are. You know what medications they take. You know their social history. You know their medical history. You know all these things about them. They don't know any of that about you.
You have this education that you understand how this medical history or this past illness or this past surgery relates to their current issues. Your name tag, the way you dress, what you're wearing, scrubs, professional attire, all these things play into it. And then when you start talking about, we're going to use this to treat you, or we're going to use a traction board, whatever it is, they don't understand what they do or how they work. So all these things build up into more and more of an imbalance between you and the patient.
I think it's really easy to just assume people know more than they do.
When patients come in, they don't always know how this relationship is going to play out. And they also have anxiety about whatever appointment is coming up.
That patient might have a history of some kind of victimization in the past.
Patients may be more vulnerable if they've experienced trauma before. They may be more vulnerable if they have feelings of insecurity, or if they're not comfortable confronting issues. If they have mental health issues, they're more vulnerable. And so you don't know who's coming in that door.
The responsibility falls on the physical therapist.
Sexual misconduct and sexual boundaries is a little bit murkier water, and sometimes you actually have two victims in the matter. So you have a sexual misconduct situation happen between a licensee and a patient, and it may appear at first glance to be consensual. You don't realize that that power dynamic essentially nullifies that consent. When that happens, it may be that the victim in the matter doesn't even realize they're the victim yet. That's inappropriate. There's a power dynamic there that needs to be accounted for.
The physical therapist really has to understand that they're in a role where that patient is looking towards them for the best healthcare advice or the best treatment. That involves explaining to the patient what that visit is going to entail and explaining the details of everything that's going to transpire during the visit. If there's good communication, it relaxes the patient. They know exactly what's going to happen.
I think it's very easy for therapists to forget that that power dynamic exists and that we are always not at the same level of the patient.
Thank you for playing those. And is there any other updates from FSBPT before I open for discussion?
Two things. Aside from the videos, one, I'll say that you are the first California students that have screened these videos. So thank you for that. How do we do? Yeah? Okay. With the videos come a few printed materials, resources for patients, resources for providers, and then also resources for educators and you as students. And so down here at the bottom, there's a printed out 2-page document that just kind of delineates some of the things that were addressed in the video, the do's, the don'ts, the slippery slopes, how to deal with things, the continuum of that relationship that might occur between you and patients, and hopefully some guidance to help you guys avoid those situations. So aside from that, the only other real update is a representative from FSBPT will be here at the December meeting in Sacramento to do the FSBPT update themselves, along with some other content.
That sounds great. Any discussion from the board or questions? I think we have like an Oscar nominee on the panel up here. I saw that we had good representation from California. I am also wanting to make sure the students know FSBPT is Federation of State Boards of Physical Therapy, representing all of the states and the territories that have physical therapy licensure. And they are the ones who control and make and standardize the NPTE. So that is also that they're a reference for us as regulators. We have a couple opportunities to get educated, as well as this wonderful consumer and student and licensee education that they're making as PSAs, basically. We really appreciate that. Okay, if there are no other comments from the board, I will take public comment from those in person about agenda item number 10, Consumer Professional Associations Intergovernmental Relations, A, B, or C on the agendas. Okay, hearing none, I'll go to online. Any teleconference questions?
All right, WebEx is open for public comment on agenda item 10. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. For our newcomers, if you have a mobile device, you may need to hit the ellipses button, that's the ... in order to find your hand. Our first request is coming from Karen Atlas. Hold on just a moment. We're sending you a request to unmute your microphone.
Hi, thank you so much. My name is Karen Atlas. I am the president of the Animal Physical Therapy Coalition, and I just wanted to chime in about the Federation because I had the wonderful and unique opportunity to serve on the task force for the Federation, and it was a task force that was formed by the Federation earlier this year with a directive to come up with Model Practice Act guidelines for animal physical therapy. So I was glad to hear that it was pointed out that the PT board very much values the work of the Federation, because I know that there's going to be a pivotal Federation meeting in October that will also include the regulation of animal physical therapy. So I am looking forward to discussing the details of this important issue at the December meeting if I am also given the opportunity to engage in this discussion. So I hope I will be able to be given that opportunity to engage at that point, and hopefully we can come to a better understanding and better better understanding of the issue that stands before us in terms of animal physical therapy. Thank you so much.
Thank you.
Thank you.
And that was our only online request for comment.
Okay, wonderful. We're going to move on. Just for clarification of those following the agenda, we had skipped down to 10. We will be reviewing 8 and 9, but we are also going to skip 11 so that we can take an opportunity to offer our time and our expertise to the students here at Loma Linda University. We're going to be doing item number 12 on the agenda, student Q&A. I just want to say I am incredibly proud of the fact that we are here at my alumni. I am excited that the students are here and that they're getting an opportunity to see firsthand that the board is an active participant in their practice from start to end, and we're not the scary big bad group that you might be concerned about, but we are here to support all of the practice of California physical therapy and here to help you be the best physical therapist you can be and physical therapist assistant. So Jason, do you want to start our Q&A process?
Sure, I'll add to a couple things. So this is a tradition that we started right before the pandemic where we wanted to put a student Q&A session on every agenda, depending on which school was hosting our board meeting. Of course, then the pandemic happened and we moved to remote meetings and that kind of thing. So we've done this about 4 or 5 times. And I will tell you that I can congratulate Loma Linda on 2 things. And it's kind of a combination thank you. You've broke the attendance record for student Q&A. And for that matter, I think yeah. And I'd even go so far as to say in the 15 years that I've been doing this job, we've broken the attendance record for board meetings. So thank you for being here. So working with Loma Linda faculty, I know that they've reached out to you as students and they've collected some questions and they gave us those questions in advance. But here's the buzz, right? It's like, we just did that, so we're prepared for the kind of questions that we're going to expect you to ask, right? So right now, we're going to look for the bravest amongst you to come down to the dais and ask your question of the board.
All right.
So an introduction, please just yes, please have a seat. Introduce yourself. We have a couple of prerequisites. Introduce yourself.
My name is Tristan.
Yep.
My name is Tristan. Nice to meet you guys.
Why did you choose this profession? You didn't know this was going to be.
I like talking
back
and I like meeting with I like working personally with people and interpersonally, and for that long period of time to actually get to know somebody. And I felt like physical therapy kind of met all of those prerequisites, and I get to work with my hands, which I like too.
Excellent. And what's your question for the board?
So I had a question regarding the specific roles of PT aides specifically in clinics and what they're allowed to do, not only just for liability, but for insurance reasons as well. And then that question kind of extended with the sexual misconduct. What happens when a PT aide is the one who performs the sexual misconduct? That is somebody that we're supposed to be watching. Does that liability fall on us?
Interesting question, right? So I'm gonna let the board take stabs at it first before
Hi, I'm Michael Knotes. I'm the board's attorney. Don't worry.
This question is directed to you.
You're not hearing from the board's attorney. You're hearing from the board's attorney. The question of liability is something separate, and insurance, that is sort of something separate from the board's activity in terms of someone seeking damages. What the board's concerned about is, and I'll let the board take that away, is in terms of supervision of a PT and what activities a PT, an aide, I do that, can perform. So I'll let you take that away.
So simply put is we are the regulator of your practice act, but you are going to be under the oversight of multiple other state agencies, private institutions, third-party payers, those kind of things. And to Michael's point, they might have requirements that restrict you further than even what your own practice act and California Code of Regulations restricts. Now, I have a canned answer, essentially, that, we refer to aides as physical therapist aides, right? They are an extension of you. They can do anything that you do, you delegate to them, but you can only supervise one of them simultaneously doing patient-related tasks, right? So we want that focus of your attention on your patient, and you're using that aide as an extension of you, another set of eyes, ears, hands, ability, to just about do any modality where you always wish you had more than two hands to do it, right? And then I'll let the board.
An extension of that is that it needs to be in direct and immediate supervision. So it does question whether or not you are stating that maybe this act happened outside of your vision or your awareness. Hopefully not. We're talking about an aide being in maybe a gym or bringing a patient back to the room, but not being alone with the patient without your knowledge and your awareness and your oversight.
Okay.
And just to clarify, PT assistants cannot supervise an aide.
Aides.
Okay.
Only a physical therapist.
About the supervision requirements for a PT to a PT assistant?
So an assistant, you can actually supervise two assistants simultaneously, and the level of supervision is less direct. You don't have to be on the premise. You don't have to be there with them. They can carry through with the plan of care, but they can't alter, adjust, or change the plan of care in any way without consultation from you as the PT. So that is that. You could use an electronic form of communication. You could use telemeans, depending on telemedicine and what facility you work at. They might have proprietary software that you're required to use, but that level of supervision could be done that way. So they are the same concept. They're there as an extension for you. Your use of them is just a little bit more free.
Can I mention something on that fact? Also, the therapist of record, the physical therapist assistant needs to be knowing who their therapist of record is. Many times in a very busy practice, there are many physical therapists and there might not have been an official assignment or awareness. And so if it ever came up to the board, a physical therapist assistant would have to name who that was, and then we'd follow up with who that was. And certainly if they didn't know they were supervising you, there might be a problem. And that could also mean telecommunication.
Does that answer? The only other thing I'd add to it is, the difference between assistant and aide is really about where the trust relationship lies, right? With an aide, we're relying on you as the PT practitioner to train them, make sure that they're doing everything they're supposed to do, hence the kind of one at a time. With an assistant, we have a whole education program, the National Physical Therapy Examination, the application for licensure process, all of those things that we can rely on to know that they are minimally competent at a certain level to do certain things, which is why it's a little bit freer in supervision and allows you to do two simultaneously.
Thank you very much.
Thank you,
Karen,
Kristen.
Michael, and Jason. Appreciate it.
Good question.
Yeah. Who's next? Here's a general question from us. No, you've got to come down here if you're raising your hand. But how many students roughly do we have in the room? I understand we have 2 DPT cohorts and 1 PTA cohort, but what's the number? 100 and something, or roughly? 120 in DPT, and then how many in PTA? 26. So we're close to like 150, right? So earlier I was talking about our outreach and education coordinator's not here, and this is her thing. Like, this is her project, this is her baby, right? So if I didn't do this right, I can't go back to work. So there's 150 of you in the room right now. When I get back to the office on Thursday, it's fair that I should expect to see 150 new likes, subscribes, right? right? Because that way I can go see April and look her in the face and be like, I did your job the way you would want it to have done when you weren't there. Yeah. It's also the best way to get direct information from the board proactively. If there's any change of regulation or legislation or announcement of board meetings or committee meetings or any of those kind of things, we will push it out. Instagram, I'm old, so I have Facebook. And then
There is TikTok.
We do TikTok. We're the only state agency in the Department of Consumer Affairs that has our own TikTok channel. And what's that? Absolutely. So as applicants and future licensees, you do have a requirement to have an email on file with us, and we will send that same kind of content out directly to your email. And I'll tell you what, it's just a secret. At the bottom of every one I send you, there's a button where you can click unsubscribe. But I'm just going to add you back 30 days later, because there's that legal obligation for you to have that on file for us to get that information pushed out to you. The other point is, as licensees, it'll be your obligation to make sure that you stay up to date and informed about the laws and regulations that govern your practice. We'll try to help with that. We'll push it out to you as quickly and as fast as we can, and multiple different platforms, but ultimately it's up to you to stay up to date for that.
I just want to mention, it's not like a overreach into privacy. It really is the fact that we certainly wouldn't want a licensee to come before us and say, well, I never got that. How was I supposed to know about that change in the regulations? So we're not trying to get into your inbox for no reason, just to let you know.
So please introduce yourself.
Hello, my name is Nathan. I'm a first-year DPT student. It's more of like a clarification and follow-up question to kind of Tristan's point about like supervision. So is it like a hard rule that one therapist supervises two physical therapy aides, or is it kind of just like a general thing?
So it's both statute and regulation.
Okay.
That a physical therapist supervises one physical therapy aide,
right,
simultaneously doing patient-related tasks.
Okay.
And then you can also supervise two assistants indirectly. And then I'm going to complicate the math even further, right? If you're serving as a clinical instructor, later in your career, you might want to contribute back to Loma Linda and provide clinical instruction to the students. And so we can add a bunch of numbers to that of students that you could also provide supervision for. And then we also have this thing called physical therapist license applicant status. So once you guys become applicants, it's almost like temporary licensure where you can go out and practice while you're waiting for your license to be issued. And you can supervise those as well, right? But we only have really the hard and fast rule or line or quantifiable number for two assistants and one aide. The law is silent in all the others, right? What I would say though is, and we kind of talked about this a little bit yesterday, and I'll just kind of reiterate it, is that while the law might be silent in something, there is this idea of community standard or standard of care. What we could all, or what most physical therapists, reasonable and prudent, would agree upon is the standard of care. And we don't want you to divide your attention too far in supervision that the quality of care falls below par, right? The way that we assure that at the board is if we had a complaint where it came to light that something bad happened as a result of this, and in our investigation, it was revealed that this physical therapist was supervising two assistants, one aide, 32 students, and 17 PTLAs, right? We would say that's a bridge too far. His attention was probably divided too much, and that would be a violation of the standard of care. As deemed on and opined by an expert consultant, right? That it's another licensee with the board that we hire to kind of look at a case and write an opinion based on what that standard of care is. So while the law is silent, it doesn't mean it's just free reign, right? You still have to do it within a reasonable number.
So in a case where you're kind of in a setting where you get a lot of patients at a time, maybe like a therapist could see like 2 patients at a time, and then you can see how like that can add up and it can get pretty chaotic where you can no longer like supervise your aides or maybe your assistants. And kind of relating back to like sexual misconduct, because you're not able to supervise as often because it's so busy, like what is the board working on so that we can like reduce or like relieve that issue? Because again, it's like a lot, right, to add like admin or like supervise all of them.
Administratively, right? There's a lot of pressure for you guys to keep up with your employer's performance expectation, the demand of care by the consumers themselves, right? I guess what I've often said from the administrator's perspective is that the best advice I can give you is that your license is your property right, right? So if the violation occurs and it occurs against your license, your license is the only thing I have jurisdiction against. So if you're feeling that pressure from your employer, from that demand, you might have to remove yourself from that situation. And it sounds like a callous thing to say, and I realize it's a lot harder to do, and it is an employer-employee relationship. Now, if your employer also happens to be a physical therapist, that can change things a little bit too, because we might chase them for that supervision issue, the violation of the supervision codes. But if you feel like your employer is placing you in a position where you are violating your Practice Act and your code of regulations, it's your obligation as the license holder to stand up against that. But I understand that is much easier for me to say to you than it is to implement.
Yeah.
Jason, can you share a little bit about how California's supervision numbers are different from other states and how we really have one of the lowest number of supervision per the other states?
So I guess it's common knowledge. You guys could all look this up yourself, but it's always something that when I say it out loud, sometimes it comes as a surprise. California is one of those states where PTs outnumber PTAs about 3 to 1. And that's not common across the rest of the United States. In most states, there are actually more PTAs than there are PTs. And I guess what I'd use as kind of a comparative is California's ratio of 2 assistants and 1 aide is very dramatically different than, say, like a state like Montana, where their law doesn't speak to a supervision ratio at all. That physical therapist can supervise as many physical therapist assistants and aides as they deem necessary. Now, I'm sure they're still subject to that same scrutiny of safe and what a reasonable and prudent physical therapist would be doing. I also think it's pretty safe to say that there's like 13 PTs in Montana, so that makes sense. You know what I mean? Like there's an actual delivery model difference for that state than there is for the economy of scale in California. There are 40,000 of you, 30,000 PTs and 10,000 PTAs in California. You can take practically the majority of the United States and you still outnumber them in just California alone. So for Montana, where that delivery model is much more rural and there isn't the volume that they're handling here, it makes sense that a physical therapist could supervise multiple assistants and multiple aides at a time because it's necessary. And that board, tasked with the regulation of that profession in that state, has deemed it safe, right? And so the models evolve over time for different reasons, and that just being one of them.
And I would also say, depending on who's sitting in front of us, clinic owners might want a different perspective. And so it's really important when these issues come up to the state that you, as an employee, have an opportunity to speak on that, because everybody has a different perspective as to why they want different regulations.
The other side of your question about what the board itself specifically is doing is, over about the last 4 or 5 years, we've started collecting a lot more workforce data as part of your application process and after your license as part of your renewal. There's a questionnaire that you would do upon renewal, and we share that information with other state agencies involved in healthcare and regulation so that we can determine underserved areas, overserved areas, retirement, balloons where where we can expect a certain amount of your population to retire within a certain period of time, and anticipate that and make, policy-driven decisions based on that data. Other than that, if you think about it, what else, the board itself advocating for the consumers of your services, what can we do to alleviate that pressure for you? A lot of those things are more market driven than they are actual government or policy.
That's it.
Yeah.
All right,
Okay.
thank you.
Yeah.
I think I'm going to call, oh, good. No, please come. I was going to say,
I have some names.
yeah. And I have the presidents of the classes. Look out. You know who you are.
Hello,
Introduce yourself.
my name is Alma. I'm too close, sorry. My name is Alma, and I'm a second-year PT student. My question was, what are the... No, I broke it.
That's embarrassing.
I'm just gonna grab
There
it.
you go.
I broke it.
We'll just-
What are the most common reasons why PTs get their licenses revoked?
Repeat your question?
Yes. My question is, what are the most common reasons why a PT's license gets revoked? Like, what kind of infractions do they commit?
So go ahead, please.
Can I ask you just a temperature probing question in addition to that? By a raise of hands, do you think it's common that a physical therapist or a physical therapist or assistant license gets revoked? Okay, good. Go ahead.
So I'm going to answer your question two ways. The first is there are some things that a physical therapist or really any other professional licensee, if they're charged with, if they've committed a crime, they may go straight to revocation. There's a due process principle that individuals have a right, a property right to practice their profession. So that has to be, that's sort of central to the discipline process in terms of the board's, so sort of their right to practice their profession and the public's right to be safe and the board's right to make sure they're doing that in an appropriate manner. So sexual misconduct, if it's proven, that's going to straight lead to revocation. There are some other substantially related crimes. If a licensee commits murder or other non-patient, those serious crimes, they will almost certainly be revoked for. But there's another, I don't know how the statistics would come across, but in the healthcare professions, driving under the influence and alcoholism, drug use is a very big concern. So the board has an alcohol program. Most physical therapists are going to start in probation. They're going to be doing the alcohol program. They're going to be doing the testing. But if they don't comply, ultimately that can go to a probation revocation, and then their license can be revoked. So I don't know. That's just sort of the flavor. But I couldn't tell you what the most common reason is. But is that helpful?
We were very lucky this morning, and you guys can go back on YouTube and watch our Deputy Attorney General, who's in the audience today, was able to do an overview of the entire process for discipline and when a complaint comes in, there, like where it goes, kind of like following the bill on a legislation. So that's a very valuable place to start. But also maybe if, Jason, do you want to outline like all the disciplinary starting from the beginning down, and that might give you some reference?
Just in reference of like the tools in the board's toolbox kind of idea. So when the board receives a complaint and conducts an investigation to remedy that situation, and one of the things that's important to note is that whatever the board is doing, they're not doing it to be punitive to the licensee, right? Our task in the matter is to make sure that that licensee is safe to practice with the consumers of the state of California. So if we are going to discipline them, That is to educate the consumers that that particular person had this behavior pattern and they should be aware of it. They can make an educated guess or decision making as to whether or not they want to receive services from that licensee. If we think that education and remediation or rehabilitation is warranted, we might impose a probationary order. And that probationary order isn't designed to be punitive either. Every aspect of that probationary order is designed in a way to allow that licensee to continue to practice while simultaneously protecting the public. And if that means that we have to limit certain modalities because of whatever the offenses were that led them to this discipline, or require a chaperone or restrict a particular age group, or in the instances of substance abuse, have them attend a rehabilitative program and do bodily fluid testing and abstain from dangerous alcohol and drugs. Those are all things that we think we need to do in order to allow that practitioner to continue to practice the art and science of physical therapy while giving us an assurance that they're safe to do so and oversight by the board to do it. Not everything leads to discipline. We also have what we call citation authority, right? So it's akin to what you might get from a speeding ticket, right? It's not an egregious violation, but it is something where we're like, well, slow down. Here's a citation. It's going to have an order of abatement. It's going to tell you don't do this anymore. It's even going to give you a little education on how to avoid it in the future. It might have a fine attached to it to serve as a disincentive, but that's also something that's publicly accessible. Citations are only publicly accessible for 5 years. Anything that's actually deemed discipline is on the licensee's record for the duration of that license's life. So, and that's why I asked, is it common that you think that PTs and PTAs actually get revoked? And hopefully the answer is no, because it's actually a rare occurrence. Statistically, I'd just say, like I said, there's about 40,000 of you, and we get anywhere from 500 to 800 complaints a year, right? So if you think about that number all by itself, that's pretty small, right? Given the size of the population and the interaction that you have with the public. Out of that 500 to 800, some of those are what we call subsequent arrest notifications. As applicants, when you enter into the profession, we're going to do a background check and you're going to fingerprint. And then we will be subscribed to your fingerprints as long as you're licensed. So if you get arrested in the state of California, the board will be notified. We'll reach out to you. We'll talk about what happened, and we'll look at it on a case-by-case basis. But out of those 500, 800, a portion of those, a good portion, about maybe 30%, are arrest notifications, right? So then you break that number down. Maybe there's like 300 or 400 actual complaints, and those complaints can be sourced from consumers, other licensees, employers, insurance companies, other like licensees, like profession on profession crime, where they're snitching on each other kind of thing. So we field all of them. And everybody that submits a complaint, that complaint is statistically registered and investigated. Now, sometimes those complaints are opened, and very quickly we can determine there's no violation. I'll give you an example, right? Like, I showed up for my appointment 45 minutes late today. They wouldn't see me. No violation, case closed, right? But that's still part of that statistical count, right? So then if you take those personality conflicts, those issues that aren't really complaints, they're better suited for something like Yelp or Google than the actual PT board, although we field them and they take up resources and we count them, the number's smaller, right? Then you get to the actual number of complaints that lead to discipline. And I think that's the more revealing number, right? So again, 40,000 licensees, the number of disciplinary actions that we take yearly fluctuates from 40 to 100, right? So really the number is infinitesimal. Statistically speaking, it doesn't have much weight. You guys are all a pretty well-behaved group of people, right? I'm thankful as the administrator that those numbers aren't always true in other aspects of professional licensure. So we're fortunate here. But sexual misconduct, your patients are incapable of providing consent to a relationship, that's a pretty, heavy tenet. Fraud, right? Anything that you're doing that is counter to the medical necessity and has motives of financial gain or anything like that can lead you directly to trouble. And then over the last 10 or 12 years or so, unfortunately, is substance abuse related issues. Yeah.
I do have a follow-up if that's okay. So a lot of times I hear stories or I'll read stories about PTs finding out that their practice has been doing like fraudulent billing. For example, maybe they're PTA and they're being billed and they have no idea, or like a PT is being like without their knowledge, they're billing extra units than what they provided. What kind of things can we do as providers to protect ourselves when that might happen to us so that we can make sure we protect our license? Like,
Yeah, excellent question.
So are you stating that somebody after the fact, after you closed out the chart and your billing, added something to the billing without your knowledge? Or are you talking about?
So there's, I've saw some stories on like Reddit or like online forums and stuff where, like, for example, the clinic without the PT's knowledge is billing extra units than what they had done. And I'm guessing maybe their EMR doesn't ask them to sign off right away or something like that. But things out of their control, like maybe admin is doing it without them knowing. Like, how do we protect ourselves?
I was thinking you were talking about before you signed off, because that is a very important thing. At the end of the day, your license is your license, and anything that's either EMR driven at the time that you sign it off, and all of that is date stamped, right? As well as any supervision that you're doing for a PTLA, and A or a PTA is under your responsibility. But what about the other? I'm not sure.
So in those situations, and I think it's funny that you're seeing those stories on Reddit, because I'm like a Reddit troll for that kind of stuff. More often than not, that will bear out in the investigation, right? So two things is, if that's something that you think is happening to you, and I'm, in the future, right? The guidance of see something, say something is always very easy to apply, right? But also be aware of the financial model that you work within. And so like upcoding and upbilling can be something that occurs against your MPI, against your license, and you don't even know it, right? And sometimes that's very easy for us in our investigation to discern, but sometimes it's not. Sometimes it's kind of murky to figure out like where that came from. And, but we're also going to look at putting the responsibility where it should lie, right? And that's why I made that kind of joke about the supervision of, if there's another physical therapist, maybe the owner of the practice, or maybe the supervisor above you, or something like that, that is more culpable for that idea of the upcoding or upbilling, we're going to open on them also, right? We're not going to stop and just take the easy road and say, we got somebody, they're responsible for it. We want to do the right thing, and we want to solve the problem for the consumer, most importantly, without adversely affecting the licensee unnecessarily. So guidance would be, try to understand the model in which you work in. And as physical therapists, you work in so many different clinical settings. Those models are so diverse, but still try. Right? Try to have an understanding of how the billing works and where you fit in that whole equation.
I'm going to try to put this back.
Let me just, but ultimately.
Yes, ultimately.
Ultimately, you should report things to the board.
Yeah.
I mean, if it comes down to it, if you've had that internal conversation, I'm trying not to give too specific advice here.
Well,
Be careful.
But the general guidance at that point would be just very similar to the supervision, where, if your employer is asking you to do something that you think subjects your own license to violation of your Practice Act, have a conversation with them. And again, I realize how awkward of a conversation that could be, and it's very easy for me to say it, but ultimately that property right is yours and yours alone. And well, we will make every attempt to find justice in the matter. You have to protect yourself also.
Hello.
Hello, my name is Thomas. I just had a question. So as we know, the APTA is advocating for our profession for insurance. but I'm just wondering, what might we see in the future in terms of reimbursement?
So this is a good opportunity to talk about the difference between the California PT Association and the PT Board of California. So how many of you got a chance to watch the video that I sent? Okay. Oh, that's not that many people. It's all good. It's all good. You can go back and watch it. It's a little outline of the prime directive of both entities. And the most important thing, and it's not just students, obviously there are a lot of licensees, a lot of consumers that don't know the difference between the responsibilities of the APTA and then by default the CPTA and the PT Board of California. So the PT Board of California is the regulation and protection agency of the consumers, right, for the practice of physical therapy. The California PT Association and the APTA are supportive and the stewards of the licensee and the profession, right? So there's some overlap, as Dr. Sims was mentioning, in things that support both, right? But ultimately, I would say the majority of reimbursement issues are propagated by the APTA and CPTA. I guess maybe if you want to share a couple options or ideas on where they might overlap or how we would become involved, that would be good.
So I appreciate the question because it's a common misconception that there's something that this board as a regulator is doing or stifling or encouraging or any kind of influence on market drivers like reimbursement. And it's not very often that regulation contributes to reimbursement rates. When the board most often is involved when it comes to billing or reimbursement is with the idea of protecting the consumer from fraudulent or unnecessary billing. Aside from that, what physical therapists are willing to do as work for a wage is completely between them and those payers, right? So it's a unique perspective in the sense that, you know, it's kind of like asking why hasn't the California Highway Patrol stepped in to lower your insurance rates for your cars? Does that hit? You see what I mean? Like one of the things that we do in outreach is to say that the PTBC is to the California Physical Therapy Association what the Department of Motor Vehicles is to AAA, right? You have to have that license to drive on the roads. You got to prove competency. You got to take a test. You got to show you can do it. But you might love driving, right? And you want to go everywhere. So you want road maps and you want towing assistance and you want all those things. The AAA is perfect for you. They got all these other the services and they advocate for you as a driver. We'll improve the roads. We'll improve the infrastructure, make them smoother, right? But DMV doesn't do that, right? And it's one of those things where PTBC doesn't do that. But CPTA does. CPTA advocates for you as a professional in things like, and we kind of talked about it right before you guys came in, reimbursement rates, you know. Now, where there's opportunity for the board is for us to be able to step in with the legislature and say those proposals that a professional association might be making, this board has no concern with when it comes to the protection of consumers. In fact, we think it's a good idea, and we'll offer a letter of support for that particular legislation.
And I would say there are a couple specifics that are demonstrating barriers to consumers getting physical therapy. As we were talking earlier about prior authorization or even healthcare disparities and the ability for people to be able to pay for services or not get it covered. Those are areas where we would be really looking to support legislature that is limiting Californians from getting access to quality physical therapy.
Which is why I'd also just say it's really important to participate with both of us, right? Like be mindful of both the professional association and the regulation of the profession also.
Thank you.
You're welcome. Come on down.
Oh, good. Hello.
Good afternoon. Oh, that's loud. Oh my goodness. My name is David Lopez. I'm a second year DPT student. This question might not be the most appropriate for y'all, but I figured I'd ask it because I'm not too bright. So,
Are you asking for a friend?
We shall see. We shall see.
Okay.
I feel like for clinicals that we go through, it is very much an open secret, at least in outpatient settings, where some places are very much focused on revenue, where they are essentially just exploiting students in order to maximize their revenue and minimize the learning experience of the student. I heard some stories, and I figured it was a good question to ask because I have a lot of students behind me. Where at what point does the student make an effort and realize, hey, this is actually just malpractice and negligence and this isn't right? Because I heard some stories of people getting left with very little to no supervision on things that we haven't even had a chance to go over with in school. So I was wondering where the line is in terms of a student experience, in terms of, yeah, this is just tough love and you just had a hard CI. Because whenever I would tell people about these experiences, other PTs would be like, yeah, it's like a thing.
Mm-hmm.
And no one really bats an eye. So I was thinking, where does that lie in terms of the legal aspect in the PTs that are actually doing this, and what can be done by a student, or I guess by the school, if they feel that they are in a situation like that where they are essentially getting exploited and are essentially minimizing the care of the patients that they are trying to see. Because in my opinion, it seems like some of those PTs have no respect for their profession, have no respect for their patients, and probably shouldn't be a PT anymore. Yeah.
So first I'll say, yeah, let's hear it. This is the perfect venue for your question.
Cool.
Thank you for asking it. I can see how passionate you are about it. I have my input, but I want to defer to the board members first.
So I think that that's a good situation to talk to your director of clinical education in your program. And that's your go-to with every clinical that you're on. And that person can help to facilitate communication when you're in a situation where you know things aren't right.
I'm chomping at the bit. I'm just giving you that. Like I have what I have to say.
I can chime in as well. I'm Dr. Kalev. I actually work at a facility where we also supervise a lot of students and residents. And I agree with Dr. Armstrong for sure. Communication and letting someone know is of paramount importance. And definitely, I mean, students matter. And when you're sensing that, there's a compromise in quality of care, that's protection of the consumer. So that should be definitely addressed in the right channels. So I encourage you as a student, all of you, to voice your concerns. It will be heard. It's important.
Next.
Yeah, please.
Okay. First, I will just start with that the intent of clinical education is just that, to educate you as applicants, not to provide a source of labor for clinical instructors in that setting. That is not its purpose. Now, we were kind of talking about the supervision ratios and why Why is the number silent when it comes to how many clinical students can, you instruct at any one given time? We realize that educational programs have frustrations with clinical placement. There's just not enough clinical placements to go around to meet the need of the number of students that are running through the programs. And again, it goes back to that kind of trust relationship with those clinical instructors to make sure that they adhere to the idea that they are bringing these students into their practice with the purpose of educating them further through their cohort until such time as they become a regularly matriculated licensee. We talked about that number of complaints that we receive. Unfortunately, some of those complaints that we receive are just about this right here. But I will tell you that as the administrator of the program, and you weren't subject to the education earlier today or yesterday, I am the complainant in the matter when we move forward against discipline with a licensee. And I have gladly signed accusations against clinical instructors who abused that relationship and utilized it as a way to supplement their employment workforce with little to no supervision so they could go on vacation or go play golf or whatever that might be. And I'll sign that accusation and I'll pursue it through to revocation because I agree with you. I think that's a scorn on the profession. Having said that, I would also say that this board has supported me in those pursuits, right? And this board, the composition of this board and its members changes periodically, but the culture in the physical therapy profession allows for that, right? So two things, I agree with Dr. Armstrong, you should deal with things at the lowest level possible that you can. So make your clinical coordinator aware, talk to them about it. Maybe that employer just needs a little, hand-holding from the school and that, so you don't lose that clinical site, because I'm aware of that pressure too. But if it escalates past that point, and sometimes those complaints are sourced directly from clinical students, sometimes I get them from clinical instructors because they made the determination at that point that this can't go any further, right? And sometimes I get that, surprisingly enough, from insurance companies or third-party payers. There's no possible way that this practitioner could have possibly seen that many patients in that small length of time. And then further looking at it, they realize, oh, there's an awful lot of clinical students, right? There's an awful lot of inappropriate use of assistive personnel, right? And we refer to those as patient mills, and that desensitizes the situation, and that's not our intent. In fact, staff at the PTBC and in the enforcement unit are just as passionate about pursuit of that as they are any other type of complaint. So again, I appreciate your question.
Thank you, David. This really represents a real passion of mine for the reason why I believe that we do have a PTBC and there's professional members on it, because what you're saying is true. How do we maintain the quality? We work really hard for what we do, what we get educated for. And so a big part of maintaining that quality is it's not whistleblowing, it's what I heard you say, which is protection of the consumer, right? And certainly is not the intent of clinical education to utilize your need for education by taking advantage of it. So I think that's really important. Thank you.
Thank you.
Shout out to those fellow Reddit trolls.
Come on down. The price is right.
And just for the purpose of expediency, you guys are welcome to come down and take this first row is lining up. Hannah, you want to come down? No? Okay, just checking on you.
Hi, my name is Dorothy. I am a first year DPT student. I just have a small question about licensure and the area that we are allowed to practice in with that license. A specific example would be, let's say we have a license to practice PT here at California, but let's say if we move to another state, then does that license still valid, or we have to take like an extension of a requirement for that state? And in addition to that, for a traveling therapist route, what would the requirements gotta be?
I'm sure there's a legal canned response about states' rights and application processes. And
I think you could do a better job.
All right.
In terms of the compact, and there's certainly there's a requirement for one to be licensed in whichever state they're going to be practicing in. So it is state by state for most professions.
Yeah.
But there is an interstate compact that you might hear about further in this discussion.
Simply put, your license gives you the ability to practice physical therapy within the jurisdictions of the state of California. And so if you were to travel to another state in respect to that state's laws and rights, you'd have to apply with them, right? Most of the requirements are fairly uniform between us in California and the 53 other jurisdictions, right? In fact, it's kind of beautiful. As a profession, I don't know if you guys know this, but you have one national accreditor for education, right? You have one national examination for competency in the MPTE, right? So that allows for better portability compared to some other professions, right, where they have more than one national accreditor. So one college is recognized by one accreditor, but not by the other. And then that kind of creates this kind of hinky situation where some states accept that creditor, but some states don't accept that creditor. Multiple pathways to licensure, right, through experience or through one examination pathway versus another. PT's clean, like everything's just streamlined and beautiful. So like uniformly, you should be able to take what you do here in California and typically apply what they call by endorsement to another state. On top of that, and I'm going to be the spokesperson for this part of the conversation, I guess. FSBPT has created what's called the National Physical Therapist Licensure Compact, which essentially means a compact is a piece of legislation that jurisdictions enter into by agreement. It's usually for interstate commerce. A good example is your California state driver's license. You can take your driver's license in California and drive in every other state in the union, right? That's just one example. There's a lot of other examples that are almost always having to do with interstate commerce. But in this instance, the concept is that if you're licensed in California, well, this is where it gets weird. California is not a member of the compact, so that's going to complicate this as an analogy. But if you were, and if we were, you would be able to take your California license and purchase what's called a privilege to practice in all of the other states that have adopted that compact legislation. And essentially, the compact legislation has just identified the lowest common denominators for what it takes to practice. So in the National Physical Therapy Compact, one of the things that they said is if you're going to enter into the compact, you have to do a fingerprint-based criminal background check. You have to impose continuing education requirements on your licensees. And so if your state, or in the Midwest or the South or the North, didn't already have those things, you would be implementing those things by entering into the compact. Makes for portability, makes for easier use as you as applicants to move from one state to another. California is not a compact-friendly state when it comes to professional licensure, and there's a couple reasons why. And I'll use the National Physical Therapy Examination as an example. It's simpler, and I'm sure at least some point today, somebody was going to ask me about why isn't California in the compact in the first place, right? I'll give you an example. Well, first of all, by a show of hands, how many of you are going to not be licensed in California? You're planning on getting licensed in another state? Okay, boo, whatever, I don't care. What state? Wow, okay, next person. Give me an example of somebody that's already made a determination you're gonna get licensed in another state. Just shout it out. Texas?
The moderator, would you repeat what the audience says?
We have one applicant applying for the state of Texas. Utah, Whatever, Hannah. I guess my point here would be, in Texas, the level that you would use to apply is you would demonstrate examination proficiency, right? They probably have their own, what we call a jurisprudence exam. It's just basically a test of the laws and regulations in that state, because your Practice Act and your regulations vary from state to state. We talked about Montana's supervision is different than California's. This is one of those things that would get covered in that exam, right? And then they would do a background check. In California, again, we're the largest state in the union by population, both citizen population and by licensure population. The criminal-based background check that we do in California is done against the California's Department of Justice, as well as a one-time capture for the Federal Bureau of Investigation. And we look at those charges to determine if you're qualified for licensure in our state. If you were from Texas and you went through Texas's application process, and then you had decided at some point you wanted to come to California, you'd be subject to California's application process. If California entered into the compact, you could take your compact license in Texas, your home license, and apply for a privilege to practice in California. And the loophole that gets created there is that if you had criminal history in California, I would never, this board would never, my staff would never be aware of it as you were practicing in California, right? So you could potentially almost subvert the application process. Maybe you know you have a criminal conviction in California, right? So you go to Texas, you apply with them, they do a one-time capture in time with the Federal Bureau of Investigation as part of their background check. And then from that point moving forward, you get a license in Texas. Here's the other thing. The data that's contained in the Federal Bureau of Investigation's NCIT system has about, by their own estimate, by their own numbers, only about 50 to 60% of all arrests and convictions in the United States. Would we say that that's a very reliable data system to rely on to make decisions for things like professional licensure and, you know, doing or utilizing that criminal-based background check? And it's a one-time capture in time. So let's just say you applied in Texas and you got your FBI fingerprint check, and then something really bad happened and you got arrested for really egregious behavior. You're already on the other side of the background check. Texas would never know, right? So it would just be a lessening of consumer protection in California for California to enter into the compact, because we already have a higher standard, and it could be a loophole that's exploited. Now, for travelers, the compact could be a very good option. You would just be limited to some of the states that aren't actually part of the compact.
Can you also speak to the concept of the difference between application and compact fee? Because even if you're in the compact, you still have to pay a compact fee.
Yeah. To govern the compact, there is what's called a compact commission, and that was put together by the Federation of State Boards of Physical Therapy. It's a separate entity now, but it was birthed from FSBPT. That compact commission essentially administers all of the different states that enter into that compact language and adopt it. But each individual state can pass their application costs on through it, right? So if you were going to apply for a privilege to practice in multiple states, you'd pay two fees. You'd pay a $45 processing fee to the compact commission itself, and then you'd pay whatever fee that individual jurisdiction applied, right? And for us in California, hypothetically, if we were to ever to enter into the compact, I couldn't really justify charging folks that were here on a privilege to practice a lesser renewal fee than I would charge my own California home-based licensees, right? I would almost consider that irresponsible in the sense that I was giving the compact privilegers an unfair business advantage over you as California licensees by making it cheaper for them to work in California than I would be making it for you to go through the whole process.
So can California dentists, do they have a compact?
No.
Do California physicians have a compact?
No.
Nurses?
No one does currently. There's been many attempts. Nursing has pursued legislation for compacts for about the last 10 years. For that matter, in the last legislative session, barbering and cosmetology was pursuing the idea of a compact. But again, it comes back to some of these ideas of what is most beneficial for California consumers and balancing that with the convenience that it provides to you as licensees and the ease of portability that you might glean from entering into this compact idea.
If I work for the DOD or the Veterans Affairs, do I need a compact?
No, if you work for the Department of Defense and you are stationed on a military base in California, effectively you are not under the jurisdiction of the PTBC or the Physical Therapy Board of California. You're actually under the jurisdiction of the Department of Defense. DOD has their own rules in a sense that they need you to hold a license to practice physical therapy in some state, right? But you're not limited to just being stationed on a base in that state. So if you have a Tennessee license, you can practice at a California base. And if there's ever an issue with your practice and a complaint's filed against you, it is the Department of Defense that will be pursuing and investigating that complaint for anything that happens within the VA or the DOD, not us.
Thank you so much.
Thank you.
Thank you. Okay, we have some more questions. Okay, come on down.
You guys are gonna have to liven up a little bit too. The whole idea here is like, you know.
Hi, everyone. My name is Jacob. I am in the PTA program, and I just had a quick question regarding what the process or I guess steps would be after passing the board exam in terms of getting the license as well as being able to start working with that license.
This would be a good test for the members, so I just want to see. Okay. The president can't be the only one talking. A couple things is the application process in California is fairly dynamic in the sense that you can apply. Well, let me ask. So I've heard year 1 and year 2 DPT. What year are you in PTA? Just and you guys just started, right? Like in June? Okay. Has anybody talked to you about creating an FSBPT account yet? Okay, we're too early, right? Okay, thank you. At some point during your curriculum, the program will create an FSBPT account for you. And then as you get closer to your graduation date, we'll transfer that account over to your control, right? There's 2 things that you'll have to do at that point. One is that you'll have to apply for licensure with this board, but that FSBPT account will allow you to register to sit for the National Physical Therapy Examination, right? And it's very clear. I want to make sure that you guys understand that those are 2 different things, but the application requires the other, right? So like I need you to take and sit and pass the MPTE. That's one of the requirements in the application for the PTBC, okay? Once you apply with this board, right, you'll pay the fees, you'll send us a passport style picture, you'll fill out the application and answer truthfully and attest under penalty. See, all these things are like so buzzkill, right? And attest under penalty of perjury that the above is true and correct, and and we will hold you to it. And then you will go fingerprint live scan. We'll do a criminal-based background check, and we'll look at if there's anything in the record that needs to be considered. If it's not, we just move you through the process. And then if you do the application process right, depending on when you apply, the only 2 deficiencies in your application might be that you're waiting to sit for the National Physical Therapy Examination, both PT and PTA, and sit for the jurisprudence exam, or what we call the CalJAM now, the Cal Juris Assessment Module. If those are the only 2 things, meaning that you got all the other deficiencies in your application already done and correct, the application's filled out properly, the picture's there, your criminal-based background check is completed and done, and there's nothing that might be a hiccup there, The only two deficiencies left are the exams. The rest of the process is streamlined and automated. If we receive passing scores, they transfer the night after the exams are released by the Federation of State Boards of Physical Therapy, and I'll touch on that in a second. The JAM, the jurisprudence exam, that used to be administered the very same way that the National Physical Therapy exam was, meaning you went to a high security, testing center, and you went through that same process, is now online. Take it from the comfort of your home at your convenience, and it's half the price, right? So we made it cheaper, we made it easier, more accessible, and more automated. If those two deficiencies hit your application, your license will issue within about 24 to 48 hours. Now, you'll get a notification that your license number is issued. If you can see your license number, and I mean in your Breeze account, which we'll touch on that a little bit too, or through the FSBPT account, if you can see a license number, that means you're licensed. You can go work right away. Now, in the interim, as part of being an applicant, you can exercise physical therapist assistant license applicant status, meaning I haven't taken the exam yet, but everything else is good. I'm ready to go. And if you can find an employer who's willing to take you under their wing, you can go to work for them. It could be volunteer, it could be paid, but either way, you have the authority to do that. You just have to follow the protocols, right? You have to have a letter that says, yes, you can. Your employer has to acknowledge that letter in the record, and they need to supervise you correctly. Well, okay.
Thank you.
We've got time for one more. One more. Okay. Oh, there's two more. Okay, we can do it. We can do it. We don't want to turn anyone away. Come on down.
I will promise to talk less. We'll try to get a couple more.
And you can ask after we're done with the formal, because we want to stay and take a picture.
Yeah.
Didn't want to hold it.
Not our mic stands. I just want to.
I appreciate it. Thank you guys for this opportunity. My name is Gianni Gaffari. I'm a first-year student DPT. So I wanted to address the point where outside of the clinic where I'm going to meet people and introduce myself as a physical therapist. I wanted to know where's the clear line that I cannot help them, and what's the bold line out of my license, and what am I allowed to do in that situation? Some advice.
For clarity's sake, clear line today as a student or clear line after your license is issued?
When I'm licensed, I guess both would be a good thing to.
Maybe I can answer to that. So we all practice under the Physical Therapy Act. So you need to be very familiar with that, because that really defines what is the line, I would say. Anyone else wants to add to it from the board members, aside from the Physical Therapy Act?
Talking about if you had a cousin or somebody ask you a question about physical therapy, right? So yeah, Dr. Khalif is right. No matter what, you're always a physical therapist with a license. And that means that depending on what the request is of that person, even if you technically are not, getting any money from it, right? You're not asking for any reimbursement, you're still going to be liable for any practice that is considered physical therapy. I think it's also really important for you to recognize that, it's all of the Practice Act still applies in terms of having to have a diagnostician's diagnosis after 12 visits or 30 days. All of that is still applicable, and that person can always still come to the board with a complaint about you. So it's just an awareness that you need to have that is, you're never not a physical therapist, I guess I could say. Is that fair to say?
Mm-hmm.
Okay.
From the administrator's perspective, identification is a very important aspect of regulation, right? Because what we're looking at is the perception of your consumer. What do they see? right? And so for you as students, it's important to identify as physical therapy students, right? At all times, so that there's not this kind of confusion that might be created for the consumer in assuming what kind of services that they're receiving. That carries into licensure also, right? In healthcare, where there are so many different people involved in the healthcare team that refer to themselves as therapists somehow, some way, occupational therapist, physical therapist, licensed, clinical social workers and family therapists and all those kind of things. It's important for the consumer to be able to differentiate between who and what services they received, right? So name tags are extremely important. Proper identification is important. Keeping your license in good standing is important. If physical therapy services are being rendered, right, you're actually providing care, then all of the Practice Act and the California Code of Regulations apply, right? And so if you're just cordial and you're having a conversation and you're providing guidance and it's something that any person or a lay person can do, I wouldn't say that physical therapy services have been rendered at that point, right? But once physical therapy services are rendered, meaning that you're actually helping somebody cure an ailment or an injury or a disease, and those are physical therapy services, then everything else that comes with that practice comes with it. The documentation requirements, the supervision requirements, all of that kicks in at that point. And that's where, to Dr. Califf's point, is being familiar with the Practice Act and knowing what a physical therapist must document, what a physical therapist assistant can't do. Some of these things, I'll tell you that one of the misconceptions is, the nature of law is not permissible. It's actually more defined there to tell you what we've identified as problematic and you can't do. The permissible part becomes undiscovered territory. And trust me, in 15 years of doing this, your profession is one of the most entrepreneurial, envelope pushing professions that arguably with the Department of Consumer Affairs, there are 38 different boards, bureaus, and commissions. And PT alone has more overlap with other professions than other professions have overlap with other professions, right? We have conversations with doctors and nurses and PAs and occupational therapists and acupuncturists and veterinarians, right? Like ophthalmologists, optometrists, like, is there anybody at DCA that PT doesn't cross over? No. Right. So it's important to understand where your scope is so that you don't you don't step outside of yours, or that you don't infringe upon someone else's.
And it still applies when I'm outside of the clinic. Like, let's say I'm hiking
Absolutely.
with some family and someone comes up to me and introduces themselves. Oh, this, am I still obligated to preach towards this person?
Here's the kicker, right? Like, it falls back to that test of whether physical therapy services are rendered. And Dr. Brandon touched on it a little bit. Like, I don't care if money was exchanged or beaver pelts were exchanged or there was a bartering system, or, like, the actual reimbursement doesn't mean anything when it comes to with the exception of fraud that gets committed against the consumer. It's whether or not physical therapy services are actually rendered, of where I'm going to be looking at how the Practice Act applies, meaning both the laws and statute, but also the regulations that were promulgated from them. So, like, how specific is the supervision ratio? How specific is the documentation? But yes, to answer your question, anywhere you go in a volunteer capacity, at the YMCA, any of those kind of places, as a physical therapist, if you render physical therapy services, you're bound by the laws and regulations that dictate your profession.
And I just want to say, on a note to that, I never want to see that happen to any of you, because you don't know who's going to report something. You might think that you have a collegial relationship or a positive rapport with somebody, but something could go wrong and they all of a sudden have called the board. So protect yourself.
The other part of it, I would say, is, as part of just a point of education, is this board is very open and transparent about all of the discipline that it imposes upon its licensees. You can go read every accusation and every disciplinary order. It will give you a very true reflection of what actually occurs that leads to discipline. And that's not really one of those things that happens very often. So, but I think hopefully it's because of the good advice, right? Like you're always a PT.
Thank you.
Okay, one more and then, yeah, are you fine to go? I'm sorry, we will take your question after.
Hello, my name is Cole. So this question, I'm part of the first year DPT cohort, and I thought this question was of relevance today just because we had our first TENS unit class today, first TENS unit lab. I'm curious about the topic of new medicine. So currently we have things like scraping, cupping, electrotherapy that are part of their staples of physical therapy. And I know that physical therapy is a relatively new treatment as compared to like medicine or dentistry. And I was hesitant to ask about this question just because the institution that we're at, but it has come from genuine curiosity. I'm curious about the topic of cannabis and CBD, like topical CBDs, and I'm curious as if what would have to happen for that to be accepted into modern treatments, just as a comparison as like scraping, cupping, and everything else had to be. And is there anything in motion currently, especially being California too?
To clarify, are you talking about physical therapists utilizing a topical for interventions that we already provide?
I'm not aware of any like topical cannabis that's already used, but if there is I would definitely be curious about knowing about that.
The first thing that I would give you as kind of caution is to zoom out a little bit and look at the way cannabis is regulated on a federal level, right? Cannabis and the way that it's involved in medicine is a controversial topic because of where it's located on the schedule for restriction. And right now it's actually identified as having no medicinal purpose and a substantial potential for substance abuse. That's one thing that has to change. And there are talks in different capacities at the federal level to look at rescheduling cannabis and where it is on Schedule 1, 2, or 3. That has to happen first for two reasons. One is, and this is, I think, very cogent to physical therapy, almost everything that you do as a profession is touted as evidence-based, right? We hear that there's studies behind it, there's clinicals, there's all these different, information to support the use of one thing in particular. As long as cannabis remains on that schedule, there are actually no studies that could be looked at with efficacy in the United States because they're not conducted here. They're conducted outside of the US, and you can't verify them or ratify them under current federal law. Now that changes and everything changes. Now, then we zoom back into California. We're different, right? We just do things different. But I would say this, I'd still fall back to that evidence-based, right? That idea, right? When it comes to topical medications, anaphoresis, and those kind of things, where you have decades worth of data to support certain things, do you have that same data to support the use of CBD infused or THC infused topical medications? Be very cautious, right? I mean, you can, I think, just let your imaginations run wild as to like what would that complaint to the board look like? And in our investigation of it, now you're starting to talk about federal violations, and involving it in the use of medication. The other part is physicians and surgeons in the state of California can't prescribe cannabis. They can give a referral for cannabis, but they can never prescribe cannabis because it's still a controlled substance, Schedule 1. So there's guidance, and then there's the lack of guidance. It's all a mystery still. I would exert as much caution as I possibly could. Does that help?
Yes, it does. Thank you very much.
Okay, so now I'd like to take public comment for item 12, which is student Q&A. And I'm presuming that that will go to WebEx for, oh no, wait, sorry, there's in person. Please come down.
My comments are germane to the board, but also to the students. So may I stand there and also face them and speak?
We could, yeah.
I'm always told you got to face the dais when you speak. So, you know, we're very fortunate here. You're very fortunate here at Loma Linda to be at Loma Linda. It was mentioned very briefly at the beginning here about a Loma Linda alum who's participating in the governance of this field, and that is Dr. Karen Brandon. I'd like to call her out. I'm here long enough to know that Karen Witter was a student of mine here at Loma Linda. I taught here 26 years. And I beat her by about 5 minutes. I got my doctoral assignment about 5 minutes for her, because my last name begins with the letter S and hers was W, so I was first and you were after me. But we're very fortunate. And my comment to you folks here is that you have a professional responsibility to learn all the, you know, brachial plexus and modality stuff. But at some point in your professional career, there's going to be a need for you to participate in the administrative portion of your profession. And that's what Dr. Brandon is doing right now. We're very fortunate here at Loma Linda to have a graduate from this fine program. Dr. Chinnick, please let Dr. Jackson and the administration know how one of our own has arisen as the president of the PT board. And there must be something, yeah. So 5 years after you graduate, then you can put your name forward to be one of these board members and help direct. You know, other than the Practice Act, the next most important entity that dictates what you do as a professional are these people up here. And we have a Loma Linda alum as the president. And of the 53 jurisdictions, there are 2 Loma Linda graduates. Mike Lehman from Loma Linda here from the doctoral program is the president of the Nevada board. So 2 out of the 53 jurisdictions have Loma Linda trademark placed on it. So Karen, thank you very much. Karen Witter, I've been so blessed to see her as a student, as a personal friend, as a clinician, as an educator. We taught together here, and now in your administrative role and continuing to serve this profession. Thank you very much. On behalf of the, I hope I speak as alum of Loma Linda, gratitude to you and for you folks here. You too can be up here in about 6, 7 years. So I hope you take opportunity. So thank you again.
Wasn't expecting that, but thank you so much.
I do a
Mike-
shameless plug after that. So
Please.
Dr. Sims just mentioned that, you know, after 5 years of licensure, you can apply to become a member of this board. And one of the things that I would just say is that, you know, participating in your professional association is kind of a no-brainer. It's a given. You should do it. But if you're looking for other ways to give back honorably to the profession, consider volunteerism. Well, volunteerism is not quite the word. I mean, we don't pay the board members very much, so we might as well call it volunteerism. But the role that they play in creating the governance of this profession is an opportunity for you as future applicants to consider and a way to give back to the people of this state. And so consider that.
Thank you. I do now want to take public comment online for the teleconference participants.
Absolutely. WebEx is now open for public comment. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few more seconds to see if we have a request for public comment. Seeing no online requests, do you wish to continue?
Yes, thank you very much. So we are going to take a brief recess for 15 minutes. We'll be back at 3:15, but we would like to thank especially our hosts, Dr. Chinnick, the faculty, everybody at Loma Linda, and we'd like to thank the students for participating. And we want to continue to see you participate in many ways in our profession. Thank you so much.
Before you guys get up.
Ready to proceed? All right, welcome back. We are still continuing with the PT Board of California first day of our board meeting at Loma Linda University. We are moving down to the next agenda item. We finished 12 and we're going back to 11, Executive Services Update. Thank you, Brooke.
Good afternoon, members. As the first year of the 2025-26 legislative session wraps up, key milestones include the September 13th deadline for bills to pass out of their House of Origin and the upcoming October 14th deadline for the governor to act on bills currently on his desk. Unless designated as urgency measures, all bills will take effect January 1st, 2026. The meeting materials include a comparison chart highlighting the July 6th House of Origin deadline. This is a key legislative milestone that typically results in a modest bill attrition. This year, 11 bills missed the cutoff compared to 18 in 2023 and 73 in 2021, reflecting a pretty consistent trend across all sessions. PTBC has taken support positions on 3 bills this session: AB 574, prior authorization, AB 1009, credentialing pathways for OTPTs in school administration, and SB 470, teleconferencing flexibility under the Badgley-Keene Open Meeting Act. The legislative report outlines key 25-26 legislation affecting PTBC. We did organize it into 2 categories. The first would be PTBC legislation that have a direct impact on PT practice or board operations, and the second is department-wide legislation that has more of a potential administrative effect on PTBC. So I'll go ahead and go through each bill that's listed on the agenda and provide an update and a brief synopsis on that. The first bill on the legislative summary underneath PTBC legislation is AB 574, prior authorization. PTBC does have a support position on this bill, and it was enrolled and presented to the governor on September 9th. This bill prohibits health care service plans and health insurers from requiring prior authorization for the initial 12 physical therapy treatment visits associated with a new episode of care. The bill is designated to reduce delays in access to medically necessary PT services and streamline administrative processes for providers. This bill was amended on June 16th in the Senate, and some of those amendments included clarifying that the bill only applies to new episodes of care and adding language around recurring conditions. It has also strengthened patient protection provisions by requiring written cost disclosures and consent, and it also specified that the bill does not apply to Medi-Cal managed care contracts. So compared to similar bills in prior sessions, this version expands patient access, is more precisely focused on PT, and adds stronger safeguards around cost disclosure and provider accountability. However, it does narrow scope by excluding Medi-Cal managed care and still permits prior authorization for reoccurring conditions.
From the board? Okay, we can move on to the next one.
Okay, the next bill that we've been discussing a little bit today as well is AB 1009, teacher credentialing. PTBC also took a support position on this bill at its June meeting. This bill was enrolled and presented to the governor on September 9th. This bill allows licensed school-based occupational and physical therapists to qualify for a preliminary administrative services credential by meeting basic skills requirements and having relevant experience. The recent amendments increase the required experience from 3 to 5 years, while permitting districts, county offices of education, and charter schools to request a waiver for up to 2 years for qualified candidates. In addition, the recent amendments clarified that the credential applies to school-based experience only and specified that the credential does not alter scope of practice under PTBC or OT licensure. The bill also clarifies that credential holders may not supervise or evaluate teachers unless they meet additional criteria.
Any questions on that one? Board? Okay, Brooke, you can proceed.
The next bill is AB 1458, animal physical therapy. And this bill would allow licensed PTs with advanced certification to provide animal rehabilitation services under a veterinarian supervision or referral. As of April 24th, the Assembly BMP Committee postponed the hearing, and it may be reconsidered when the legislature reconvenes in 2026. for the second year of session.
Are there any questions on this or comments?
Maybe just a recommendation from staff. Based on requests, we think that it would be appropriate to provide an opportunity at the December board meeting in Sacramento to put together, very similar to what we did at UOP for dry needling, a symposium, an informational session. I participated in an informational session with the Joint Committee, the Assembly and the Business Professions Committee, not particular for AB 1458, but for its Chiro bill counterpart. The Veterinary Medical Board EO, the Chiropractic Board EO, and I both provided just testimony on the regulations of the profession, but also, got to sit in on sessions and hear questions from both senators and assembly people about those services and the difficulties that they are running into. This is a 2-year bill now, and so as far as expediency, we have time to have this as a discussion. I think the December board meeting logistically plans out well when it comes to travel, and gives us enough time to make sure that all the relevant stakeholders have the opportunity to participate.
I think that's a great idea. I think that there needs to be an opportunity for the board to evaluate the information regarding this and the current practice, and have some information that comes from maybe FSBPT or other stakeholders that already have this in practice in their state. So we have a reference of some kind, even though that's not determinant on what California will do. It's just good to understand how it has been utilized in different states.
We will have a representative from FSBPT there to provide the FSBPT update, who just happens to be the staff member that was assigned to the FSBPT Animal Rehab Task Force that Karen Atlas mentioned on the call. And so we can ask her to do kind of a State of the Union report where animal rehab is in the United States, where it exists and in what models, and then also speak to the end product that the task force has created as far as proposed regulatory language. So I think that part will work out well. I'll reach out to a couple of the people that participated in the informational hearing and find out if they're also willing to either attend in person or maybe even remotely to contribute to the conversation too.
Anyone on the board have input regarding that opportunity or any additions they want to share with Jason and the staff to include? Okay. I had a question. I don't know if it's appropriate at this time, Council. I wanted to understand what happened with the Chiro bill. If it is a 2-year bill, is it also like?
It's also a 2-year bill.
Okay, got it.
Yeah.
Okay.
And I can speak to that in the sense that it is the intent of the Joint Committee to address both bills simultaneously because of the nature of the language and its relation to the Veterinary Medical Board. So that's why we were also, as the physical therapist side of it, invited to that informational hearing, and we might have that opportunity again in the future as the session progresses.
I had a question about the bills in terms of are they very similarly written in terms of the content and the coverage of scope? Are they different significantly? We can get into it later. I just want to understand, are both parties asking for the same things?
No. The significant difference between the two is the Chiropractic Board is taking more of the regulatory burden on and less on the Veterinary Medical Board as compared to the 1458 bill, which talks a little bit more about collaboration between the two, but does house it and center it underneath the Physical Therapy Practice Act. The Chiro bill is a little bit more territorial in the sense that it is completely contained within the Chiropractic Act.
And the supervision component they're asking for the same level of supervision?
Because the Chiro side is asking for it to be regulated solely by the Chiropractic Act, the supervision requirement between a veterinarian and a chiropractor is less established than it is for us in 1458.
Okay. Yeah, I just want to encourage the board members to review that information, and we'll provide any accessory addenda resources that you need to be prepared for December. Okay, if you have any questions, check in with Jason and
And we'll
staff.
continue to put out education as we come across it.
Absolutely. Thank you.
One of those being the FSBPT's most recent release of the task force's product.
Thank you. Okay. Is there anything else, Brooke, before we go on to B?
Oh, no, I still have a few.
Oh,
more
sorry,
bills.
sorry. You're going to keep going. So sorry.
That's okay. There's quite a few on there.
I see.
The next bill is AB 224, healthcare coverage, essential health benefits. And this bill was enrolled on September 10th, and it updates California Essential Health Benefits Benchmark Plan starting January 1st, 2027, pending approval from the U.S. Department of Health and Human Services. And it updates the insurance code. Applying to plans regulated by the Department of Insurance, it expands required coverage to include hearing aids, infertility treatment, and durable medical equipment. For physical therapy, this means DME such as walkers, braces, splints, resistance bands, and neuromuscular stimulators. These would be covered when medically necessary and prescribed by a licensed PT or physician. This coverage would apply to both short-term rehabilitation and long-term functional support, depending on the clinical need. So while health plans may still apply reasonable utilization controls like quantity limits or prior authorization, they can no longer impose blanket exclusions on that. This bill is a companion bill to SB 62, which I'll be talking about in a few minutes here. This one, again, is more specific. It's amending the insurance code.
Okay.
Next bill is AB 489, Healthcare Professions, Deceptive Terms or Letters, Artificial Intelligence. This bill was enrolled and presented to the governor on September 10th and expands existing laws against deceptive healthcare titles to include AI and Gen AI technologies. It prohibits AI systems from using protected titles, for example, DPT, MD, doctor, without licensed oversight. It requires disclaimers and provider contact info for patient-facing Gen AI content and treats each misuse as a separate violation. The recent amendments that occurred clarified enforcement authority, which made unauthorized use of a protected term or credential a separate violation enforceable by the appropriate Healing Arts Board, and strengthened disclaimer requirements and aligned provisions with the California's advertising and competition laws.
I have a question about this one. Jason, or maybe Michael, can you describe an instance where this would be supportive of protection for a physical therapist utilizing, or the consumer rather, when a physical therapist is utilizing AI for a component of their care?
So I think the deceptive terms and letters for artificial intelligence is more geared towards institutions or corporations that are creating models to replace licensees, right? And so you might be using an app or a web app or a video conferencing call and being, as a consumer, under the impression that you're talking to a live human being or communicating with a live human being attached to a license in some way. That's the intent here by kind of restricting and then also bolstering the board's authority. I also think, while I appreciate it, we see it a couple different ways. If physical therapy services are being rendered, they're attached to a license. So if AI is used by that licensee, AI is being used the same way any other tool would be utilized by a licensee, and we'll rely on our expert consultants to define what the standard of care is at that point. And that it may not advance as quickly as people may like, and it might still result in changes in legislation. But until then, that's the tool that we have before us. The other side of that is similar to the intent of this bill for deceptive terms or letters. If we come across something that is purporting to be or holding itself out to be a physical therapist and there is no license attached, we will pursue it as though we would pursue any other unlicensed practice complaint. And if that means that there's a software provider, a software developer that is infringing upon the PT scope and even going so far as purporting to be a physical therapist or holding themselves out to be a physical therapist, we would treat that the same way we would a human being who was doing that, and we'll pursue them accordingly.
So as a frame of reference, if someone were to create a app that was my neighborhood PT with no physical therapist interfacing with the patient that actually is registered to practice in California. This would be protecting the consumer under the unlicensed practice.
Correct. And we would pursue that investigation to determine, one, if the Practice Act was infringed upon and physical therapy services were rendered, and if they were, who was responsible for that, and identifying that that person is not a licensee. The authority then we have at that point is a citation authority. Well, before that, we also have a cease and desist authority, right? But after that, subsequent to that, and in finding of wrongdoing or finding of unlicensed practice, we could sanction that person with a citation. And that citation can be based on per instance or per occurrence with a pretty hefty fine as a deterrent.
Yeah, I think my mind is getting blown thinking about programs already that exist that maybe utilize a physical therapist who is licensed, but they're taking care of multiple care groups and how that's going to, be a challenge for us to evaluate and what other issues it might bring up.
You have some very set in stone requirements of it's expected that a physical therapist provides care to the patient at least once per the session. Those kind of things are still rules that would need to be adhered by. Supervision rules would still be implemented, so I mean, there is definitely a lot to be considered.
Thank you. Any other questions about that one? Okay.
489.
If somebody is practicing as a PT,
Mike.
if somebody is practicing as a PT, but they're not licensed, does that, other than cease and desist order,
there are further remedy, right? So aside from cease and desist, aside from citation, I can pursue criminal prosecution with the help of a local county or municipality district attorney and file criminal charges for that person violating that Practice Act. And for that matter, that actually goes for every offense within the PT Practice Act. Every offense can be prosecuted to the extent of a criminal misdemeanor charge.
okay, that's exactly what I was trying to ask. Thank you.
Okay. Continue, please, Brett.
Okay, moving on to AB 667, examinations interpreters. This bill was enrolled and presented to the governor on September 10th. This bill does not apply to healing arts boards. It requires beginning July 1st, 2026, that each non-healing arts board under DCA allow applicants who cannot read, speak, or write in English to use an interpreter when taking a license examination. The next bill on the ledge summary is AB 742, DCA licensing. Applicants who are descendants of American slaves. This bill was enrolled and presented to the governor on the 22nd of September. This bill will require each licensing board under DCA to expedite licensure applications for individuals who are certified as descendants of American slaves. This bill defines expedited as prioritizing application review and reducing administrative delays. The bill is contingent on the enactment of SB 518, which would establish the Bureau for Descendants of American Slavery to oversee the certification process. Okay, AB 1186, data collection, race and ethnicity, minimum categories. This bill was enrolled and presented to the governor on September 10th. AB 1186 establishes standardized minimum race and ethnicity categories for demographic data collection by state boards, including those under DCA. By January 1st, 2029, California agencies must use 7 minimum race and ethnicity categories: Asian, Black or African, American, Latino or Hispanic, White, American Indian or Alaskan Native, Native Hawaiian and Pacific Islander, and Middle Eastern or North African. Agencies must also collect data on the 6 to 9 largest subgroups within each category and include write-in options to ensure inclusive representation. This bill applies to new and existing data collection efforts used for licensure, enforcement, workforce analysis, or public transparency. This bill was amended in August and clarified that boards may collect additional subcategories beyond the required 9. They also added language to ensure compatibility with federal and state data standards and also provided implementation flexibility for those boards with limited data infrastructure.
I think when we discussed this one before, we thought that it was really important that they identify what the purpose was of the collection. And Is that in the actual bill language?
It is, but it's also, it is, but the clarity is still.
Okay.
But I'd also say it's just an expansion of what we do today. We collect race and ethnicity demographic data in the current survey response. This is just changing the number of categories that we would identify.
And also having an open-ended one
Yes.
for self
Yes.
identification, right? Okay. Thank you.
Okay, moving on to SB 62, healthcare coverage, essential health benefits. This bill was enrolled and presented to the governor on September 10th. It updates, again, the essential health benefits benchmark plan beginning January 1st, 2027. It is similar to 224 that we discussed earlier. This one is a companion bill. Both of these bills are focused on obviously updating the state's essential health benefits, whereas 62, it updates the health and safety code. SB 62 expands the required health plan coverage to include hearing aids, infertility treatment, and durable medical equipment such as walkers, wheelchairs, and mobility scooters. And it also mandates coverage of medically necessary mobility devices used in rehabilitation. With the most recent August amendments, it clarified federal approval requirements, it defined DME, and also specified implementation timelines as well. The next bill is SB 470, the Badgley-Keene Open Meeting Act teleconferencing bill, and the board did take a support position on this bill at its June board meeting. SB 470 extends the sunset date for teleconferencing provisions under the Badgley-Keene Open Meeting Act from January 1st, 2026 to January 1st, 2030. These provisions allow state bodies, including PTPC, to hold public meetings via teleconference under specified conditions, which would improve accessibility and operational flexibility. The key provisions under this bill include the following. It authorizes state boards to continue using teleconferencing without requiring public access at each remote location, provided certain transparency and participation standards are met. It also requires agendas to clearly identify teleconference locations and access instructions. It also mandates that a quorum of members participate from locations within California. It preserves public participation rights through remote access platforms and applies to regular and special meetings, but not to emergency meetings. The most recent amendments extended the sunset date to January 1st, 2030. It also clarified quorum and location requirements for remote participation, and it also strengthened some of the language around public accessibility and technology reliability as well. The next bill, SB 518, Descendants of Enslaved Persons Reparations. This bill was enrolled and presented to the governor on September 22nd. This bill establishes the Bureau for Descendants of American Slavery within the California Civil Rights Department. So this bill creates divisions for genealogy, education and outreach, and legal affairs to verify descendant status. It also is focused on supporting access to state authorized benefits and safeguarding personal and genetic data. And the final bill on the legislative summary is SB 641, DCA and Department of Real Estate States of Emergency Waivers and Exemptions. And this bill was enrolled and sent to the governor on September 10th. This bill grants the Department of Real Estate and DCA boards the authority to offer regulatory relief to licensees affected by declared emergencies. It also allows waivers for exam deadlines, fees, and continuing education. It mandates clear waiver procedures. It bans unsolicited property offers in disaster zones and supports debris removal coordination as well. The August amendments clarified waiver authority. They added some transparency reporting. They strengthened consumer protections and enhanced coordination with emergency agencies as well. And that concludes my legislative update. I'd be happy to answer any questions that the board members may have.
Maybe I heard wrong. AB 667, which is the interpreter's bill.
Oh, yes.
It looks like that did not pass the Senate.
Oh.
I'm not sure what happened there because it's very odd for a bill to make it all the way through both houses. And then it was held at third reading. So it made it a really long way before it held.
Thank you for that catch, Michael. I appreciate that. It looks like it was ordered to inactive file at the request of Senator DeRosa on the 11th.
Are there any other questions on the legislative report? I think I can go to the next agenda item and then we can, I mean, not the item, but the sub item, which is.
Legislation and regulation would be separate.
Oh,
So if you're concluding.
okay, then, okay. We'll do public comment then now. Any in-person public comment on the current agenda item? (11A).
Still, here we go, good. Yeah, just, is it in order now to ask for that letter to go to the governor or in support of the two bills? Okay, so is that a question? I don't know how to phrase it. I gotta make it an interrogatory then. It's a question or just a comment? Yeah, my comment would be that I think it'd be beneficial if the board would write a letter subsequent to the letter they wrote already in support, but to the governor to sign the bills. And that'd be AB 574 and AB 1009.
And I think that there doesn't have to be a motion if it's in the purview of the
That is within your purview as the board
Board.
president, and you have a number of different ways to make that happen. You can draft those letters yourself. You can instruct staff and I to draft those letters. So you can accept the comment.
Oh, thank you.
And then the other question was, or comment, the December, there's going to be time earmarked to have a longer discussion or regarding the workshop?
So to the member of the public, this is a public comment portion for the legislative report. You can direct those questions to the PTP staff following the meeting.
Okay, well, then my comment will be that I look forward to if the board will be able to have something where information, breadth and depth of the issue can be fully exposed or whatever. The other comment is my first email regarding this was in 2006. It's been 20 years that I've been kind of wallowing in this stuff. So we'll go from there. And last thing, just maybe just editorial in nature. On the legislative summary, it says for AB 1458, it says dead for 2025. And when a bill is dead, there's connotations that it either didn't come out of committee, or whatever. It's not.
Right.
It just got held over to a 2-year bill. So I don't know if that's an edit that we should have occur. And no position. I thought that there was a neutral position taken on a couple meetings ago. And I think it should be instead of, my comment is looking at the definition of the positions of watch would be more appropriate. That's my comment, not ask.
Yeah.
I want to make sure I want to make sure I'm in order here. I'm not stepping over.
I can answer it in the sense that I'd answer that question to anybody that asked it any opportunity, is that watch is actually a stance that staff takes on behalf of the board. Neutral is a more official position that the board itself would take based on that recommendation. So when we bring it to the board as a watch, these are the pieces of legislation we've identified that could potentially affect the physical therapy board or the Department of Consumer Affairs for that matter.
Thank you. Are there any comments online for agenda item 11A?
All right, WebEx is open for agenda item 11A. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And our first request is coming from Karen Atlas. Hold on just a moment. We're sending you a request to unmute your microphone. All right, Karen, we're going to try again. We're sending you a second request to unmute your mic. If you're on a mobile device, you might need to hit the ellipses button. That's the dot dot. I see you're unmuted.
All right, let's try this again. Thank you so much. This is Karen Atlas. I am the president of the Animal Physical Therapy Coalition, and we are a coalition of all the different stakeholders, including veterinarians, physical therapists, registered vet technicians, animal owners, and search and rescue handlers, law enforcement handlers. So basically stakeholders of all folks that are interested in getting physical therapy and rehab care for their animals. So I just wanted to make a comment about the Senate Business Professions and Economic Informational hearing in August. It was a wonderfully comprehensive meeting, and I encourage the board to listen into the about 3.5 hour session. It's really enlightening. One point of interest, though, was that Mr. Kaiser gave a really great overview of how the PTBC regulates its licensees. And he also provided his opinion that animal physical therapists should be regulated by the Veterinary Medical Board and not the PT Board. So in light of this opinion, because AB 1458, which we are the sponsors of, would house animal physical therapists into the Physical Therapy Practice Act. So I would encourage the board to take a deeper dive on how PTs have been taking actually a leading role in our own profession in this area. And it'll be evidenced by the Federation's recent Model Practice Act standards for this area of practice on animals, as well as the APTA's engagement group, which is housed within the Academy of Orthopedics. So we have, it is the practice of physical therapy, and we are hoping that the PT board will recognize us and be able to name us as legitimate providers of services. We are looking for a collaborative model with the veterinarians. We think that veterinarians should be the gatekeepers of services and provide a referral under their direct or indirect supervision. Supervision would be up to them, but we would be named as legitimate providers within our own act so that we can use our skill set in the best way possible to expand access to care in a safe manner. Thank you so much. Appreciate it. And I look forward to hopefully engaging with this board in more detail about this important issue in December. Thanks so much.
Thank you. Are there any others on our telehealth or teleconference?
There are no others on WebEx.
Thank you. All right. I would like to then move on to item on the agenda 11B, rulemaking report. Brooke again, thank you.
Of course. So I'll go ahead and direct members to the flow chart from the DCA regulations unit, which is on page 59 of the meeting materials. That just outlines the 4 stages of the regulatory process. Oh, was it on it? Is that better? Test. Yeah.
You just have to bring it closer to you.
Oh, it keeps falling. For the continuing competency regulations, staff are currently in the first stage of the regulatory process, which is known as the concept phase, where proposed language is being explored and roughly drafted. During this phase, we are actively researching, collecting workforce and program data to support the development of 2 regulatory packages. The first would be an amendments to the existing continuing competency regulations, and the second would be a new package addressing approval agency fees. So additional updates will be provided under the licensing report, agenda item 20, but I'd be happy to take any additional questions on the rulemaking report that members might have.
Any comments or questions on the continuing competency rule? I don't think so. Okay, and then I can take any public comment. In person, no public comment noted. Any public comment online?
WebEx is open for public comment on the rulemaking report. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few more seconds to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, thank you. And we are going to go on to 11C, which is communication and education update. And April is looking very different today. But thank you, Jason, for being here in her stead.
I already feel like I did April justice with the wave and the students. So I don't have much to prove at this point. But I do have the script for her briefing paper. And so I'll just start with that.
I don't hear you very well. I don't know why. Maybe it's me.
I can make it much louder. So for the website in fiscal year 24-25 quarter four, the PTBC had 53,666 web hits through its website page tabs that resulted in a 17% decrease from last fiscal year quarter four. For Facebook, the PTBC received 36 likes this fiscal year quarter four. In comparison to last fiscal year, there was a decrease of 30% in page visits and an increase of 18% of page reach. Compared to the last fiscal year, the PTBC increased its Facebook reach by 4.7%. Any questions for either of those two? The fiscal year quarter four PTBC had a 4% increase in page reach for Instagram and a 1% decrease in profile visits in comparison to last fiscal year quarter four. Compared to last fiscal year, the PTBC increased its Instagram reach by 13.2%. I love that last metric that she's providing in each category because it kind of speaks to the overall performance of each social media platform. And we're starting to see that reflected in the demographic data we collect in renewals also. There's still an increase in Facebook, but only by 4.7%. There's an increase in Instagram by 13.2%. And as you'll see as we go farther on, it kind of bears true. When looking at TikTok stats for fiscal year 24-25 quarter four, PTBC had 760 new video views or impressions, resulting in a 73% decrease compared to last fiscal year. TikTok also had 36% new followers and 14% new likes. Compared to last fiscal year, the PTBC's TikTok reach decreased by 45.8%. When looking at X stats for fiscal year 24-25, the PTBC had a decrease of people reached by 80% and a 23% decrease of page engagement compared to last fiscal year quarter four. Twitter also had 0 new followers this quarter compared to last fiscal year. The PTBC decreased its reach by 39.9%. For LinkedIn had 3,760 page reach impressions, resulting in a 56% increase compared to last fiscal year. LinkedIn also had 113 page visits, which resulted in a 105% increase compared to last fiscal year quarter four, as well as 176 engagements, which resulted in a 291% increase compared to last fiscal year quarter four. Compared to last fiscal year, the PTBC increased its LinkedIn reach by 7.5%. For outreach workshops and webinars during fiscal year 24-25, the PTBC provided 5 virtual outreach programs or workshops to 5 PT and PTA programs during quarter four. And for 24-25 fiscal year, the PTBC conducted a total of 30 school program outreach workshops, which is roughly about 3 a month. The PTBC has also started providing outreach to consumers and had 2 health fair events this month, with more in the works for the following fiscal year. This will be reported on more at the next board meeting in December for fiscal year 25-26 quarter one report. That concludes the outreach report, but I'm happy to answer any questions that you might have.
I had a simple question. Are we posting the same information across all of these social media platforms?
We are, with very little variance. So there are certain formatting issues that can affect picture versus video kind of when it comes to X, Instagram, and TikTok. But for the most part, we've figured out how to turn pictures into slideshows into videos, that kind of thing, so that the messaging is consistent across all platforms.
Are there any other questions? Go ahead.
Social media, are we
Your phone,
targeting
your microphone.
Are we targeting certain population, let's say, age groups versus, our profession
So
students?
in some of the social media platforms, you can categorize the reach of your posts based on certain classifications like healthcare, government agency, those kind of things. That's the extent of the steering of the material that we've done. We have not spent any money or investment into targeting demographic data. Right now, we've utilized social media as kind of the free advertising tool as it is. Like today, though, when we had the opportunity to talk to 160 students, we try to sell the social media so that we can target it in that way. We also encourage the program directors when we're doing outreach to do the same thing. The material itself will at least contribute to the algorithm to a certain extent based on what kind of content we post, but we have not invested in any kind of financial steering or means through social media.
Okay. I guess my final question is looking at the outreach calendar, and I know we had brought it up before, but it might be because of our fiscal limitations for travel that it sure seems very North California heavy. And we did talk about the ability to do video presentations. What are our opportunities to be equally, is it based on invitation? What are we doing to make sure we have the entire state covered with the same opportunity?
Absolutely. It's a little bit of all the above, right? So we can seek out and recruit educational programs, but we're also limited by the extent of their acceptance. And so some programs are more apt to have us more often. The NorCal SoCal isn't as distinctive a difference as you might think. A lot of the Bay Area and Northern California outreach are also being conducted via telemeans, Zoom, Teams, WebEx, that kind of thing. And because travel is restricted to mission critical and essential, it does make it difficult for us to kind of justify Bay Area travel or Southern California travel for that matter. It's not to say that we can't do it. The more often that we try to do it, though, it's going to limit our resources. So we have kind of deferred back to the telemeans, and it's worked out well. It does seem like, at least once a week, there is an outreach event that's occurring that either April or Paul or Valerie or I or Sarah are, teaching or attending. So that part is increasing. And then adding to that, what does reflect in Northern California is April has added to her tool belt consumer-oriented outreach, right? So we're going to health fairs for skilled nursing facilities and within specific insurance payers and that kind of thing. In doing that, because it's local, we're taking advantage of it, and we're using it almost in a laboratory fashion to kind of polish our content and make sure that it's a whole new audience, right? So the outreach has to be catered to the audience. And in a very short period of time, we've done 3 or 4 high schools, and we've done 3 or 4 healthcare fairs now. And so we're reaching farther down into more elementary education, but also extending our reach into the consumer population. And because it's a new experience, we're taking a lot of notes and we're creating content as we go. But that's the hardest part to get the invitation for. Although in this last outreach event, just attending that last outreach event has already borne 2 or 3 invitations to other healthcare events, again, local into the Northern California region. But we'll use that as a laboratory opportunity also.
Thank you. Are there any other public questions for item 11C? Public comment? Okay. Hearing none, I'm going to ask the moderator if there are any online.
WebEx is open for public comment on the communications update. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. And just a quick note, whispers are not whispers, they are recorded. That being said, there are no requests for public comment.
Thank you, and thank you for making me aware of that, moderator. Then I'm going to move on. For item number 13, we do not have any items for closed session at this time. And so I would like to move on to item number 14, which is public comment on items not on the agenda. Having none in the audience at this time, in person, moderator, can you ask for online public comment?
WebEx is open for public comment for items not on the agenda. This might be your last opportunity to make a comment today. So please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment longer to see if we have a request for public comment. Seeing no request, you wish to continue?
Thank you very much. All right, well, we are going to be in recess for our board meeting until tomorrow morning at 9 a.m. We will still be meeting here at Loma Linda University in the Centennial Complex, and look forward to seeing you tomorrow. Thank you.